Have you ever thought about buying a home without having to deal with a bank? It's called seller financing, and on the surface, it can look like a dream come true. But, well, that dream can turn into a total nightmare pretty fast. So today, we're going to pull back the curtain and uncover the hidden dangers. For a lot of people, maybe their credit isn't perfect or they just can't get a traditional mortgage. This seems like the perfect workaround. We're talking about something often called a contract for deed. You work directly with the seller, you make your payments to them, and you get to move right in. It sounds so much simpler, right? Less red tape, and a door opens that the bank might have slammed shut. And yeah, the appeal is obvious. But here's the thing. This path is often a legal Wild West. It's unregulated, and the contracts are usually written to protect the seller, not you. That promise of easy home ownership, it can fall apart in a heartbeat if you don't know exactly what you're signing. So let's get into the risks you absolutely need to be aware of. To really get what's going on here, we have to put on our real estate attorney hats for a minute. It all boils down to two really important ideas that sound similar, but are worlds apart: legal title and equitable title. This is where things get tricky and where most of the danger is hiding. Okay, first up, legal title. Just think of this as the master document, the official deed that's filed with the government saying who owns the property. In a contract for deed, the seller hangs onto this, the legal title, for the entire time you're making payments. You could be paying for years, even decades, but on paper, the house still isn't legally yours. So while the seller's holding the legal title, you, the buyer, get what's called equitable title. Now, this means you have the right to live there, to fix the place up, to enjoy it like you own it. But, and this is a huge but, it is not full ownership. It's kind of like having a season pass to a theme park. You get to use all the rides, but if you break the rules, they can kick you out and they don't have to refund you a dime. And this right here is the fundamental difference between this kind of deal and a normal bank mortgage. So let's put them side by side and really dig into how different these two paths are. This chart really lays it all out. Look at that first line, ownership. With a regular mortgage, you get the legal title, the deed, the day you sign the papers. The bank has a lien on the property, sure, but it's your house. With a contract for deed, the seller keeps that title. And check out the legal protections. Mortgages are buried in federal and state laws that protect you. These contracts? Not so much. But the scariest part is the default remedy. You miss a mortgage payment, you go through a long foreclosure process. You miss a payment on a contract for deed, you could just get evicted, fast. And this is the weapon that lets them do it. It's called a forfeiture clause, and it's in almost all of these contracts. What it says is, if you miss even one payment, the seller can cancel the whole deal, kick you out, and keep every single dollar you've ever paid. Your down payment, all your monthly payments, gone. You walk away with absolutely nothing to show for it. As if that wasn't risky enough, a lot of these agreements have a little surprise waiting for you at the very end. It's a financial trap, a ticking time bomb really, designed to go off when you least expect it. And it's called a balloon payment. So the contract might have these nice, affordable monthly payments for, let's say, 5 years. But then, at the end of that 5 years, the entire rest of the loan, the whole balance, is due immediately, all at once, in one giant lump sum. Now, most people don't have that kind of cash lying around, so the only option is to get a traditional mortgage. But what if you still can't qualify for one? Well, you default on the contract. And that forfeiture clause we just talked about, it kicks in and you lose everything. And the dangers just keep piling up. For one, what if the seller has their own mortgage on the house? If they take your payments but stop paying their bank, the bank can foreclose on your home. Then there's the price. These homes are often sold for way more than they're worth, which makes it almost impossible to get a bank loan for that balloon payment. On top of that, all those on-time payments you're making, they usually don't even get reported to credit bureaus, so you're not building your credit score. And yes, there are outright scams where people will sell you a house that's already being foreclosed on. Okay, now let's talk about a really specific, kind of complicated type of seller financing called a wraparound mortgage. This one comes with a whole new set of risks for everybody involved. So in a wraparound, the seller keeps their original bank mortgage and they give you a new one that kind of wraps around it. You pay the seller, and the seller is supposed to use that money to pay their lender. You can probably see the problem. For the buyer, if the seller just pockets your money and doesn't pay their bank, you lose the home. For the seller, if the buyer stops paying them, they're still stuck with that original mortgage payment. Both sides are completely at the mercy of the other person doing the right thing. It's a house of cards. So, after hearing all of these horror stories, you're probably thinking, how can anyone possibly protect themselves? Well, the good news is some lawmakers are finally starting to pay attention, and there are definitely things you can do to build a legal shield around your investment. You might think, hey, aren't there federal laws for this? And you'd be right, sort of. The Truth in Lending Act, or TILA, does have some rules. But here's the kicker. It only applies to sellers who do this kind of thing more than 5 times a year. And as you can see, that's only about 8% of all sellers. The other 92%, the vast majority, are totally exempt. That leaves almost all buyers without these basic federal protections. That's why state laws are so incredibly important. Let's look at Louisiana. A few years ago, they passed a law, Act 450, that gives buyers some real teeth. Now, sellers have to give you a formal written notice if you're in default. Then you get a 60-day window, a right to cure, to get caught up on payments. The law also forces the contract to be publicly recorded, and maybe most importantly, you can't be talked into signing these rights away. It's a fantastic model. But the problem is, very few states have laws this strong. So let's say you're not in a state with great protections. What do you do? Well, here is your playbook. Think of this as your personal safety checklist to go through before you even think about signing on the dotted line. Step 1, and you cannot skip this, you have to verify the property's legal status yourself. Do not just take the seller's word for it. You need to hire a title company to do a full search for any hidden debts or claims against the property. You call the county tax office to make sure the property taxes are paid up, and if the seller has a mortgage, you get them to sign a form that lets you call their bank directly to confirm they're current on their payments. Okay, next up is the contract itself. You need to insist on getting your own appraisal so you know you're not overpaying. And of course, a home inspection. The contract has to spell out crystal clear who pays for property taxes, who pays for homeowners insurance, and who's on the hook for major repairs. And here is a pro tip. Try to get a clause in there that allows you to pay the seller's mortgage lender directly. That one little thing can prevent a world of hurt. Now, this might be the single most important thing you do. As soon as that contract is signed, you take it down to the county recorder's office, and you get it officially recorded. This creates a public record. It tells the entire world that you have a financial interest in that property. It can protect you if the seller tries to sell it out from under you or take out more loans on it. Do not skip this. Look, we've gone through a bunch of steps, but they all lead to one simple, non-negotiable rule. You have to hire your own real estate attorney. Not the seller's attorney, your attorney. This is not a do-it-yourself project. A good lawyer will spot all these traps, they'll protect your interests, and they'll make sure you understand exactly what you're getting into. And honestly, this goes for the seller too. Everyone needs their own legal advice. So here's the bottom line. Seller financing can feel like a lifeline, but it operates in a legal gray zone that is just filled with risk. A handshake deal or a simple one-page agreement is not enough to protect you. In the world of real estate, an agreement means very little, but a recorded, legally sound document means everything. So the question you really have to ask yourself is this: are you willing to bet your future home and all your money on anything less?